Meeting to order. Welcome to meeting number 35 of the House of Commons Standing Committee on Justice and Human Rights, continuing our study on elder abuse. Just really quickly before we get into the weeds, for everybody, members and witnesses, just please take note of the interpretation that is available for this meeting. At the bottom of your screen, you'll see a globe icon with the interpretation. Please select the language that you'd like to listen to. You should be able to speak in any language that, any official language that you choose. And just please note that before speaking, wait to be acknowledged by myself. And also, before you speak, please unmute yourself. Speak slowly and clearly so that translation does not have any issues. And then once you're done speaking, please put yourself back on mute. And a reminder that all comments should be addressed through the chair. With respect to a speaking list, Mr. Clerk and I will do our best to ensure that everybody who needs to be heard will be heard. Now, before we welcome our witnesses, there's something very quickly I just want to address with members of the committee. I'd like to inform you of a situation that occurred last time that we met on Thursday, May 13th. Due to technical issues, two parts of our meeting on Thursday did not have proper audio on Parlview, and we heard white noise instead. So these gaps occurred when Mr. Moore was speaking and Mr. Virani was speaking, when they were questioning witnesses specifically, and it totaled about 11 minutes of the total time that we heard that white noise. Now, unfortunately, it seems unlikely that our technical services will be able to recover that sound of those missing moments. We are expecting a letter from the head of the committee's directorate about what happened, and we have already received reassurances that everything will be done to avoid any reoccurrence like this in the future. Now, I invite members if they have any witnesses. Okay, not hearing any comments, we'll go ahead.
Sorry, Madam Chair. From my end, you cut out there, so I couldn't hear you speaking at the end, ironically. I'm trusting that the Hansard record for that those sessions still exists and will appear on the written record. And if so, I hope then that other members of the committee will be satisfied with that, but since it wasn't my time that was whited out, I leave it to them.
Thank you, Mr. Garrison. Now, my understanding is just recently confirmed that that the Hansard records will be available. Mr. Clerk, if you'd like to clarify that.
Yes, absolutely, they will be.
Okay, so they will ultimately form part of our deliberations for the report. Mr. Virani?
Yeah, I mean, it's regrettable that it happened, but the fact that the Hansard record, so a transcription is still available, that is sufficient for my purposes. But if we can just make sure that this doesn't happen again, it's a pretty significant matter when parliamentarians are doing their work at committee and the committee records aren't as in the form that we were expecting them to be. So if we can just make sure that there's different sort of measures put in place to ensure that there's live recordings, audio recordings, visual recordings, etc., on multiple fronts, so that this doesn't occur again, that would be appreciated. Thank you.
Thanks, Mr. Virani, and we have been given reassurances that that all measures will be taken to ensure that it does not happen again. Sorry, I just want to clarify, Mr. Clerk, the 11 minutes that are missing, will they be recorded or reported in the Hansard as to what happened in those 11 minutes or no?
No, they won't. The answer will be published, but let's say without these two gaps, basically, because the audio has been, we've been unable to recover these two gaps. And so it applies also for our transcription team as well. So there will be also these two gaps in the written version, let's say, of the meeting, unfortunately.
Okay, thank you, Mr. Clerk. So just to clarify, we do not have, whether in writing on the Hansard or audio transcripts of these 11 minutes from our last meeting of question and answer from members of witnesses. on this study. Are members okay with that? I mean, and then also obviously we're taking steps to ensure that it doesn't happen again.
So, Madam Chair, that's a bit of a different answer. So I'd be curious to hear what Mr. Moore thinks. I mean, the difficulty is that I didn't have the questions that I had sort of reduced to writing necessarily. Sometimes it's a bit extemporaneous, so it would be hard to put the questions, to recollect the exact questions I put to which witnesses. So we neither have the videotape nor the written transcription for those 11 minutes.
That's correct.
Is what you're saying, and they can never be retrieved. We've exhausted
correct.
all possibilities. Right.
Mr. Moore, if you wanted to provide your insight.
Sure. I mean, maybe in the interest where we have witnesses here, I don't think there's anything that can be done. You've probably, Madam Chair, done everything that can be done, and if these comments or questions are lost, I don't think any of them were ever going to be made into a heritage moment or anything like that. So, but it's being addressed. So I think we'll just probably move on would be the best thing.
All right. Thank you very much for that, Mr. Moore. Any other comments on that? Okay, not seeing any. Then we'll invite our witnesses. Thank you very much for being here today. We welcome l'Association de Barreaux Canadienne.
The Canadian Bar Association.
Lyle, président, section de droit des personnes aînées.
The Elder Law Section.
Président, section de la justice pénale.
And the chair of the Criminal Justice Section.
We also have CanAge, represented by Laura Tamblin Watts, who's the president and director general. We also have Haley Mason, who's agent de la politique from CanAge. Welcome. We also have Réseau FADOC, representant
the FADOC network, Gisèle Tessé-Goodman, who is the president of the Provincial Secretariat.
And Denis
Prudhomme, the Chief Executive Officer of the Provincial Secretariat.
And so I'm just, before we go into the opening remarks, I'll just draw your attention to my 1 minute and my 30-second time cards that will help you in keeping time for your opening remarks. And we'll start with the Canadian Bar Association for 5 minutes. Please go ahead.
Helps if I unmute. There we go. So good morning, Madam Chair and honorable members of the committee, and good afternoon to those of us in Nova Scotia. My name is Jessica Lyle, and I'm the chair of the Canadian Bar Association Elder Law Section. With me today is Jody Burks, chair of the Canadian Bar Association Criminal Justice Section. Thank you for inviting the Canadian Bar Association to participate in your committee's study of elder abuse. I join you today from the traditional territory of the Mi'kma'ki people. This territory is covered by the treaties of peace and friendship, which Mi'kmaq and Wolastoqiyik Maliseet people first signed within the British Crown in 1725. The CBA is a national association of more than 36,000 lawyers, notaries, law teachers, and academics. An important aspect of our mandate is to seek improvements in the law and the administration of justice, and that is what brings us here today. We would like to commend the federal government's support for older Canadians in the 2021 federal budget. The support comes on the heels of the CBA's recent calls for improvement of long-term care, including the creation of a pan-Canadian elder abuse strategy. We are not here to recommend any changes to the criminal code. Parliament nonetheless has a vital role to play in combating elder abuse. We recommend a pan-Canadian elder abuse strategy starting with the following 5 points. First, legislate universal minimum standards for long-term care facilities. Clear minimum standards would ensure these most vulnerable members in our society receive the care they need. Additionally, where a facility failed to meet the standards, they would serve as clear evidence for prosecutions. Second, law enforcement must recognize elder abuse as a criminal offense, not a private matter between families or individuals. Third, provide specialized and appropriate training in prosecuting elder abuse for police and Crown Counsel. A dedicated case management system, including the use of testimonial accommodations, should also be considered. Fourth, hold corporations who fail to prevent elder abuse in their facilities accountable. Sections 22.1 and 22.2 of the Criminal Code provide that, in addition to the individuals charged, the corporations employing these individuals may be held accountable for the same offenses. Fifth, increase resources for education and community support. For example, legal aid resources and specialized clinics are extremely limited in Canada, with only 2 permanent clinics, one in Vancouver and one in Toronto. I will now ask Jody Burks to address additional issues.
Thank you, Jessica. The criminal offenses listed in our submission already cover activities which fall within the category of elder abuse. Furthermore, some of the offenses, for example, theft by person holding power of attorney in Section 331 of the Criminal Code, already address a unique aspect of elder vulnerability. We believe increased resources and training around enforcement are better measures to combat elder abuse, not new offenses. One of the most significant issues in elder abuse is the vulnerability of the complainants in a relationship involving a significant power imbalance. There are several tools already in the Criminal Code to provide for testimonial aids to support vulnerable witnesses, such as the use of support persons in the courtroom, allowing witnesses to testify via closed circuit television, found at Section 486.2 of the Code. And there is an ability in the Criminal Code to use a videotape statement as a witness's evidence in chief, provided they adopted a trial, found at Section 715.2 of the Criminal Code. We note that the Advocacy Center for the Elderly and CanAge have suggested the creation of a new offense to this committee. With respect to that position, this proposed offense is already covered by the existing offense of criminal negligence causing bodily harm or death. Additionally, the vulnerability of complainants in the criminal justice system is addressed through the mechanism of release conditions that prohibit contact between accused and complainant. Similarly, any attempt to intimidate or dissuade a complainant from testifying is already punishable under the Criminal Code. Elder abuse and neglect are often cited as being where domestic violence was 20 years ago, when policy was undeveloped and Crown Counsel and the police did not have sufficient understanding, tools, or clear direction to address the power and control dynamics within the victim-abuser dyad. As a greater understanding of domestic violence evolved, improvements to its framework were made. We suggest that the same approach be employed in the case of elder abuse. Thank you again for the opportunity to appear today. We look forward to answering questions you may have.
Thank you very much for that. We'll now go to CanAge. Please go ahead. You'll have 5 minutes.
Thank you very much, Madam Chair and members of the committee. My name is Laura Tamblin-Watts, and I'm the President and CEO of CanAge, Canada's National Seniors Advocacy Organization. We are a pan-Canadian, nonpartisan, not-for-profit organization. We work to advance the rights and well-being of Canadians as we age and ensure that older Canadians can live vibrant and connected lives. With me today is Haley Mason, Policy Officer at CanAge, with whom I will be co-presenting. I will present the first portion of our oral submissions, and Ms. Mason will conclude. CanAge will divide its comments into the 3 substantive areas: criminal justice reform, prevention and awareness, and responses and research. Our first recommendation is to create an elder abuse and neglect specific criminal code charge. I have studied the work of criminality and elder abuse for more than 20 years, and there is little actually that indicates that this is not appropriate. And with great respect to my colleague, I do think it is time for a criminal elder abuse charge. Police involvement, charging, and the criminal justice system have been minimally involved in elder abuse and neglect. This has, by contrast, been frustration from the public and for police officers that they do not have the needed tools to adequately respond to increasing spread and impact of elder abuse and neglect. There is coverage missing. It's important to create a criminal code provision for ease of charging for types of abusive or neglectful behavior which do not fall squarely within the commonly existing highlighted provision of underlying offenses. There are quite simply gaps in the criminal code related to elder abuse and neglect which need to be filled. Also, having a charge for criminal elder abuse and neglect is important for the goal of deterrence. Specific charges take a clear message that abuse of vulnerable older adults is not just a civil matter and provides scope for multiple charges to be laid. The off-cited Section 215, failure to provide the necessaries of life, is in fact a charge very rarely laid. In the elder abuse and neglect context, this charge is typically only laid in the most extreme and profound circumstances, such as leaving an older person in an unheated garage to die of starvation and sepsis due to untreated wounds. But much abusive behavior of older adults deals with blocking or restraining of liberty, the invasion of privacy, predatory types of tracking, grooming, and coercion. CanAge has had the benefit of reviewing the materials from the Advocacy Center for the Elderly and is supportive of considering their suggestions for a new charge of criminal endangerment. However, CanAge would like to draw attention to the recently considered Bill 218 on controlling or coercive contact within intimate relationships that this committee has heard recently. I'm going to turn now to my colleague, Ms. Mason, to continue.
Thank you, Laura. Our next recommendation is regarding the prevention and awareness of elder abuse and neglect. Recommendation B6 funding provides sustained and appropriate funding for elder abuse and neglect response on par with domestic violence funding. Particularly provide dedicated support and funding to the Canadian Network for the Prevention of Elder Abuse and other elder abuse and neglect response and educational agencies or organizations. Awareness. Support and implement a national elder abuse response strategy. As part of the NEARS, integrate the new criminal code provisions, including training and awareness campaigns. Data reporting. Require federally funded, and federally regulated agencies to collect desegregated data on elder abuse and neglect and the experiences of older adults in segments more defined by narrower age groups. 65 plus is too large a group, and disaggregated data should also include other self-identified characteristics to better understand marginalization and intersectional impacts on older adults. Responses and research. PIPEDA. Amend PIPEDA to better allow financial institutions to report abuse. Amend Section 73D32A, define financial elder abuse and mental capacity. B, update the list to whom disclosure can be made. And C, link to provincial and territorial responses. Research. Release the groundbreaking elder mistreatment study research into the light by Dr. Lynn McDonald, submitted to the government in 2015 and 16. This landmark report was funded by the Government of Canada with additional funding from provinces and territories. It was the largest study in Canada on elder abuse and neglect and one of the largest and leading studies globally. However, for unknown reasons, this study has never been formally released by the government. A small portion can be found online. Additionally, the Government of Canada must invest in research to better understand and respond to elder abuse and neglect, including funding the NICE network. Thank you.
Thank you very much, Ms. Mason. We'll now go to our last, but definitely not the least, presenter, Réseau FADOC, for 5 minutes. Please go ahead.
Madame la Présidente, je vous remercie. Mesdames.
Madam Chair, thank you. Honourable parliamentarians, my name is Gisèle Tassé-Goodman, and I'm president of the FADOC network. With me is Denis Prudhomme, Director General. First of all, I'd like to thank committee member for this invitation. Our network brings together people 50 and over. We have over 550,000 members. Each of our political efforts is designed to contribute to improving quality of life for seniors. Unfortunately, once again, we need to talk about the scourge of elder abuse. During the COVID-19 crisis, ageism, evident in word and deed, has been exacerbated. Our organization has written to the Human Rights and Youth Rights Commission because the rights and freedoms of seniors have been seriously breached with lockdown, and age-related abuse has been common. For example, the public declaration of Patrick Lévy, who owns Olympia, who suggested that people 65 and over should not be admitted to in theatre events so that the sector could recover more quickly. This kind of statement is unacceptable, inconceivable, and, of course, intolerable. Although age-based discrimination is prohibited under the Charter of Rights and Freedoms, there is too little awareness of this. Many people are not aware that they are victims of ageism and don't have the courage of starting a complaint. The federal government needs a national communication campaign to discuss this form of discrimination, as well as raise awareness of possible recourse for victims. Age-based discrimination is very frequent among experienced workers. Verbal abuse is common. Work organization schedules are poorly adapted to their needs, and they lack ongoing training. Statistics show that unemployment increases with age, which highlights particular issues with experienced workers. We would like governments to more actively support experienced workers in order to allow them to stay in work longer. Ongoing measures and measures implemented should focus on ongoing training, orientation, and bring them back into the workforce. Abuse of any kind should be condemned and penalized. Since abuse is frequently carried out by someone close to the senior person, victims must be made aware of this issue. Government funding could provide for workshops organized by groups and organizations to help seniors recognize what is an unacceptable situation. This should be done as a priority in senior residences and community groups that seniors frequent. Best practices can be set up. We focus on appropriate treatment, also known as well treatment. This is a concept that focuses on well-being and safety. FEDOC also wants to highlight the issue of organizational abuse. This is any situation where organizational procedures create a situation that prejudices care or services for seniors and compromises their health and safety. For a number of years, the Quebec health system has been under much pressure. Lack of human resources, successive waves of reform, and lack of investment means that patients have no access to quality care and services. Nonetheless, funding for provincial health care takes up 40% of provincial budgets and territorial budgets, while the Government of Canada funds only 22% of health spending. The federal government must increase health assistance for provinces and territories, which have great difficulty in covering those costs. Medical advances and an aging population are doing nothing more than exacerbate healthcare costs. In order to reduce the underfunding, FEDOC is asking the federal government to increase Canadian health transfers by 6% each year. There should also be a variable included that takes into account the aging population in provinces and territories as healthcare transfers are calculated. I would like to thank committee members for listening. Mr. Denis Prudhomme will answer questions, and I may also answer some myself. Thank you.
Merci. Thank you very much. We'll now go into our first round of questions for 6 minutes each, starting with Mr. Moore. Please go ahead, sir.
Thank you, Madam Chair, and thank you to our witnesses for appearing today on this important topic. To the Canadian Bar Association, you mentioned in your testimony the need to treat some situations as criminal code matters and not as a private matter. And I think, I know where you were going with that, but could you expand on that a bit, how some matters involving elder abuse, senior abuse, tend to be grouped more as a private family matter and not maybe the criminal code offense that they actually are?
With your permission, Madam Chair, I can answer that. Thank you for that question. It's a really important question. It's a question that deals with enforcement. The criminal code is there to enforce just sanctions against people who commit criminal offenses. In the context of domestic assaults, just to borrow an earlier example, 20 years ago, when there was an assault that happened in the domestic context between husband and wife, or between boyfriend and girlfriend, or between partners, the police would often come in, separate the parties, and say, you guys need to work this out. This is between the two of you. And that left too many victims vulnerable to continuation of abuse. Abuse was kind of swept under the rug, hidden away from the public view. It was only after a concerted effort by the provinces, by law enforcement, by advocacy groups to bring this kind of abuse to light that things were actually starting to be prosecuted in the criminal code. And now there is robust prosecution. The same analogy can be drawn in the context of elder abuse. For far too long, police would come in, do an investigation, speak to one of the parties, usually the party in the controlling the complainant in the matter, the elder in the matter, and say, you know, they're just crazy, or they're this or that or the other thing. Care wasn't taken to remove the potential victim from that situation and talk to them one-on-one. Talk to them in a way that allows for a different form of communication. Talk to them in a way that accounts for the fact that they may be afraid to come forward and name their abuser and say, I am fearful for my life or safety. We need training of law enforcement officers on how to ask the right questions in the right way to develop that evidence. And then there needs to be a will to bring these charges forward, not to view this in the context as a purely family matter or private matter that, you know, the police come in and just say, they're there, you know, just calm down, everyone just separate for a bit and we're going to go away. These cases need to be investigated properly and then prosecuted vigorously. And that is the context that I am talking about. Thank you.
Okay, thank you, Mr. Burks, for that answer. And to CanAge, there's a lot of discussion about a controlling relationship, people not being on an equal footing. Can you, from your work as an advocacy group for older Canadians, can you explain a bit how that evolves and why it's so important that we treat this maybe differently than we do other matters?
The coercive and controlling behavior, which I know this committee was recently reviewing, came out with key recommendations, and they dovetail extremely well to elder abuse as well, because some of the engagement can be around keeping people away from other people, making sure that there is an interruption in flow of their lives, in coercive or near coercive behaviors. It's CanAge's recommendation that the report number 9, the shadow pandemic, stopping coercive and controlling behavior in intimate relationships, would be appropriate if expanded for elder abuse and neglect. And for clarity, the recommendation was everyone commits an offense who repeatedly or continuously engages in controlling or coercive conduct towards a person with whom they are connected that they know or ought to know could, in all of the circumstances, reasonably be expected to have a significant impact on that person, and then has that impact on the person. Again, the recommendation from the committee was around considering a hybrid offense with a maximum of 5 years imprisonment. So the expansion of this particular provision would be appropriate to consider just beyond intimate partner and domestic violence relationships, but include it into the elder abuse sphere as well.
Thank you for that. Can you maybe expand a bit on what are some of these typical behaviors that you may see that are crossing the line as you see it in that relationship, perhaps between caregiver and older Canadian, or family member and older Canadian?
Well, it is true that about 3/4 of all abuse and neglect that's not scams or frauds are perpetrated by those closest. That, of course, is analogous as well to domestic violence and intimate partner violence. What we can say is that there's blocking behavior, there's behavior that keeps people away from activities, there's behaviors that look like stalking and harassment, coercion, and very much on the basis of, you know, you can't go see your grandchildren unless you do these things for me. So it's that exchange of power and control that we think of often in domestic violence relationships are deeply analogous in elder abuse as well.
Thank you.
Thank you very much, Mr. Moore. I will now move to Madame Brière for 6 minutes. Please go ahead.
Thank you, Madam Chair, and thank you to all of our witnesses today. My first question will be direct to Mr. Burks of the Canadian Bar. Vous avez indiqué dans vos...
In your remarks, you indicated that, in your opinion, the criminal code is sufficient to deal with elder abuse. In fact, sometimes when we try to be too specific, we might end up missing the point. Do you believe, however, that some amendments should be brought to the criminal code so that it is better able to deal with the issues we're discussing this morning?
Thank you, Madam Chair, for the question. To be clear, actually, I'm sorry if I misstated earlier. I do not believe any amendments are necessary to the criminal code. What we need is more vigorous enforcement of the offenses that are already there. As the member pointed out quite rightly, if we craft an offense that is too specific, what we may end up doing is creating loopholes that, if we don't prosecute with such specificity, the guilty might escape on what the public perceives as a technicality, but is really criminal legislation is always strictly constructed and strictly applied because we are dealing with fundamental rights such as a liberty of an accused person. I would point out that the offense that CanAge and other advocacy organizations propose is exactly the same as the offense of criminal negligence. I can tell you the offense of criminal negligence criminalizes anyone who is criminally negligent who, in doing anything or in omitting anything to do that they are obliged to do, shows wanton or reckless disregard for the lives and safety of other persons. This offense is tailor-made to prosecute elder abuse. Long-term care facilities are under legislative obligations to provide for the needs of their clients. And if they act in a way that is harmful or fail to act in a way that causes harm, this offense squarely criminalizes that conduct. Not only would the perpetrator of that conduct be liable criminally, but potentially the organization as well through the use of Section 22.1 and 22.2 of the Criminal Code. That legislation was brought forward in response to the Westray Mines tragedy out east that would allow corporations to be similarly prosecuted. And if you want to get at the heart of profit making, you must prosecute these corporations. So I apologize if I was unclear before. All the tools are there in the criminal code. We need the will and the training to use them to prosecute elder abuse. Thank you.
Thank you. Et comment faire alors pour...
So what can we do to make sure that such cases are reported?
Certainly what we need to do is we need to start on the ground. Organizations such as CanAge and other organizations have done a brilliant job of educating the police on how to investigate these types of offenses in a careful, considered, and victim-focused fashion. What we need to do is ensure that the police prosecute these offenses, receive that training. Once a charge is laid, the criminal code provides for protections for complainants from accused persons. There's bail conditions and release conditions that require that an accused person not contact directly or indirectly an alleged victim, not be within 100 meters, area restrictions. All of these protections come into play once a charge is laid. So the first step would be to have these organizations help train the police. The federal government has a role to play in legislating mandatory minimum standards for long-term care facilities. Also creating centers of excellence where police forces from across the country and Crown prosecutors from across the country can come and be trained and have uniform tools and applications and a knowledge base. all of these are within the federal mandate. All of these would increase accountability for elder abuse, which must be stopped.
Thanks again. Et maintenant pour la FADOC.
Now for FADOC, I'd like to take this opportunity to highlight your two initiatives. One's called Par la fenêtre, and one is Prenons soin des autres, one through the window and let's take care of others. You have helped some 40,000 seniors. That's wonderful. During the calls you make to seniors, have you been able to find new problems? What is the issue that most seniors are experiencing? Thank you for the question. What's really important and what we've realized is that people felt very isolated. Initially, those who were receiving home care had to lose their care temporarily until sanitation issues could be dealt with, and that could last a long time. The issue that led to is that people who were receiving care, well, 3/4 of people who were receiving care saw that their circumstances worsened because they did not receive the care they needed, first of all, and second, because there were things that they were unable to do. So there was a case of organizational abuse by failing to take care of people, by failing to provide the care needed. People's health worsened both emotionally and physically. Thank you.
To Monsieur Fortin. Monsieur Fortin, voulez-vous commencer pour 6 minutes?
Mr. Fortin, 6 minutes. Thank you. Well, first of all, thank you to all witnesses here today. Your presence is extremely important. You are shedding light on the work we're doing here on the committee, and elder abuse is a very important subject. My question is to the FADOC representative. Mr. Prudhomme was answering, but I was also interested in something that Ms. Tassé-Goodman said, the issue of increasing health transfers. This has always been a priority. In fact, it's essential, but I think the pandemic certainly highlighted major gaps in funding for the healthcare system and social services in general. I'm very happy to hear this testimony, which I find absolutely relevant and appropriate. Elder abuse is being looked at here not only as a lack of services offered, but also as an issue that requires potentially new criminal code measures so that the situation, unacceptable situations, can lead to penalties. The representative for the Canadian Bar Association stated that in the criminal code we already have all the provisions we need. We just have to find a way to make sure these provisions are applied. It may be that stakeholders in the system, in the judicial justice system, need training, for example, lawyers and judges. Could our FADOC witnesses tell us whether, in their view, current measures that exist in the criminal code are indeed sufficient to cover all forms of abuse that elder people might be subject to, or would new offences be needed? Thank you. Thank you for the question. In Quebec, there is a new bill that would reopen the justice system and include organizational abuse as an offense. As the president of FADOC said, we are also asking the Human and Youth Rights Commission to deal with isolation and abuse issues and everything that is pertinent to them. In closing, I'd say that across the world, well, the UN is currently working on an international convention for the rights of seniors, and it shows that even though there are penalties in the justice system, there are so many gray zones and so many ways to circumvent the existing systems that we have to make sure that these gray areas are covered. You say that you're working on a bill that would add criminal penalties, but there are provisions in the criminal code. Now, the issue is, are these provisions properly applied? Have you looked at this? Are existing measures being properly used? Two aspects to my answer. I think we do have tools that might do the job if we wanted to use them, but quite often it's the definition of issues relating to abuse and ill treatment that are just not black and white. This is what we're being told, and this is why we believe that we should review both the reporting system and the consequences once we find that a complaint is properly founded. But what isn't covered, Mr. Prudhomme? Assault, murder, kidnapping, unlawful confinement. What is covered? What isn't covered, I should say, and should be? Well, for example, when you forget or omit to give someone appropriate medication, when you forget to provide care, hygiene care, taking the time to feed someone instead of going too quickly, taking time to help someone do the things that they can do rather than doing them oneself because there's no time to take the time. So many issues are simply not black and white, and that is why definitions need to be far more precise. I think in listening to you, you're talking about institutions and homes for the elderly. In the private sector, older people who live with families or who live alone, do they have similar problems or are their problems different? As another witness said, carers, close carers, family, well, all too often, unfortunately, they are the ones who abuse seniors or neglect them. Thank you. I'd also like to hear you talk about the UN. I know that you worked there for a while, and you say that they're working on a convention for the rights of seniors. Perhaps in my second round, or I could ask the question, or someone else could. Thank you for being here today.
Merci, Monsieur Fortin. I really appreciate that. We'll now go to Mr. Garrison for 6 minutes. Please go ahead.
Thank you very much, Madam Chair, and thank you to all the witnesses for being with us today. I want to start with a question to CanAge, and I first want to thank them for bringing up the parallel with coercive and controlling behavior. As I'm sure the witnesses are aware, it's a subject very dear to my heart. And what we heard in testimony on that was that domestic violence legislation often was too incident focused and too focused on the most severe incidents for it to be used effectively against domestic violence. So I'm assuming that's the point you're making here. Is there something lacking when it comes to patterns of neglect that we're trying to get at here through an amendment of the criminal code?
Thank you so much. It's precisely that. With great respect, I do know that there are, of course, fundamental building blocks and things like assault, things like theft and criminal responsiveness. But there is an importance to naming elder abuse. And there are gaps in patterns of behavior around violence that do not necessarily get captured alone. We also are not afraid of the principles of Pineapple, where you may have one or more charges which overcome each other. So you may have impaired driving and over 08. It doesn't mean that you may not also have an assault or a theft or a fraud or a theft pursuant to a power of attorney charge. But that controlling behavior, that pattern of abuse is not, with great respect, captured as such in the criminal code. And we believe, like we did with other designated offenses, such as intimate partner violence, and such as has been considered by this committee, that elder abuse falls into that category as well.
Thank you very much. I want to go to the Bar Association then and ask about the function of denunciation that I think Ms. Tamlin was talking about, that as well as the specific offenses, the criminal code does serve a social function in specifically denouncing certain kinds of behavior as criminal, as not acceptable. And so the Bar Association has argued that things are already covered in the criminal code. Then it's hard to explain why there aren't charges being laid, why we haven't seen any prosecutions, for instance, of corporations for neglect in long-term care. So are you really certain that we couldn't get at this better with a specific offense of criminal endangerment that would go alongside other offenses, as Ms. Tamlin points out?
Thank you very much for the question, Madam Chair. It's a very good question, and I think the member brings up an interesting point. There is that proposed legislation there is no element that's different than the current element of criminal negligence. All of the elements are exactly the same. So it's not even a pineapple issue. It's a duplication of offenses. It's not that there aren't the tools there. It's the willingness to use the tools that are there. You talk about denunciation. Section 718.2 of the Criminal Code talks about sentencing principles. And it says a sentence should be increased or reduced to account for any relevant aggravating or mitigating circumstances. And one of the, under sub 3, evidence that the offender in committing the offense abused a position of trust or authority in relation to the victim. That is exactly the dynamic that's present in the elder abuse. So the code already allows for an aggravating feature, for a longer sentence, for a harsher sentence. And that is how denunciation, how society exhibits denunciation, is in the sentencing principles. And the justice who hands down a sentence is not only entitled to, but obliged to call out that specific dynamic in the elder abuse and say, normally I would sentence you to a year, but I am sentencing you to 18 months to account for the fact that you took advantage of your elderly parent who trusted you, who raised you, who loved you, who guided you, and who you were obliged to show that same respect to. So with the greatest amount of respect, that's there already. And what we need to do is get the police and the prosecutors to investigate and the prosecutors to prosecute.
With the permission of the chair, I just want to chime in and add one piece to that, because I think there's a focus here today that's focusing very much on the criminal code. But the bigger point is this is not just about the criminal code. This is about education in using it. This is why we're talking about a pan-Canadian strategy. This is why we're talking about those minimum standards, but it's why we're talking about special training for prosecutors, for police, for judges that also, of course, respect judicial independence.
Thank you very much, Ms. Lyle. But with the greatest respect to both of you, when you say it's already in the criminal code, elder abuse is not specifically there. And so what you're talking about is abuse of trust, and you're expecting those to insert elder abuse into their reasoning. I want to turn to another proposal, and that is to create an offense that would make the retaliation against complaints in places like long-term care an obstruction of justice offense. And again, I would assert that while you may say there are obstruction of justice offenses there already, it might be useful to add a very specific offense with regard to retaliation in complaints in long-term care. And could I get your thoughts on that?
So thank you for the question. In terms of the suggestion that there isn't a specific offense called elder abuse, there's actually neither a specific offense called domestic abuse. It's captured under domestic assaults. Domestic assault is a basket term, but the offense is simply assault.
That's why we're proposing a controlling and coercive behavior amendment to the criminal code. Exactly why we're doing that.
Thank you. But my sincerest apologies. We're out of time for Mr. Garrison there. Perhaps we can pick this up in the next round. So we are moving to our second round of questions, starting with Mr. Lewis. Mr. Lewis, you have 5 minutes. Please go ahead. Mr. Lewis? Madam Finley? I don't see him on the screen.
he is having internet connection problems. I know that, and for some reason I thought it was Mr. Cooper's turn, but
Okay, well, if Mr. Cooper wants to go ahead, I have on my sheet here that it's Mr. Lewis, but Mr. Cooper, please go ahead.
Oh,
I can go ahead.
Go ahead, Carrie Lynn. Go ahead.
Sorry. All right, a little confusing with the internet issues. Thank you all for being here with us today, and we really.
I'm so sorry, Madam Findlay. Can you please move your boom down?
Sorry, here we go again.
Thank you.
All
Thanks
right,
very much.
I'm got it now. Wasn't expecting to be on right now. Anyway, thank you all for being with us today. We certainly do appreciate it. I would just like to, I guess, start with having the witnesses speak to what they felt they couldn't finish in this last question. If you could go ahead and more fully answer, please.
I'm just going to jump in here. Thank you for that.
Go ahead. Go ahead.
I think part of what seems to be missing from this, the CBA has two national resolutions, and our resolution that the criminal code is sufficient is from 2011. That continues to be the position of the CBA until we have a change. So that is where this position starts with. But part of what our point is that there needs to be a lot more education on a more societal basis, because the tools may be there, and yes, possibly they could be enhanced. That's not what the CBA is here to discuss today. My concern is that, for example, where domestic violence came to, we separate the two individuals and we talk to them separately and ask them to figure it out. On the elder abuse front, often what creates the shades of gray is the introduction of the issue of dementia. And dementia is time specific, it's activity specific, it's location specific. So there needs to be much more implementation of that national dementia strategy and having those conversations with all of the members of the justice community so that they understand that just because somebody is apparently incapable at the time doesn't mean that the suspected abuser gets a pass. And that's the point that I wanted to convey. It's so much more than just the provisions of the criminal code. It's actually using them, whether there is a new one or the existing ones. That to me is not the issue. The issue to me is supporting those people who are on the front lines, who are making these decisions, who are in place, so that the police who want to lay charges have the support of the prosecutors and judges who understand what's going on. That was really what I was trying to add in.
Well said. Thank you very much. I having a former legal practice in doing a lot of family law that intersected with elder abuse issues, I do understand that some of the big issues here in prosecution are the willingness of witnesses. Sometimes they themselves maybe don't realize that what is happening to them is abuse. Secondly, they don't realize they have options. Thirdly, when it comes time to prosecute, often older people who are vulnerable, perhaps financially and emotionally, are afraid of the consequences of speaking up. And what I've seen with police officers is often, well, if we get them into a safer situation, let's just let it go, because all of that is very complicated. So I'm interested in what the Canadian Bar Association sees as a way to support elders who are able to come forward or support them. I mean, with children, we have things like child advocacy centers, for instance, because they're vulnerable. Is there something you see as a way forward that perhaps federal government could fund or support that would help take what is already in the code or just common decency into action for the elderly?
Certainly, Madam Chair, thank you for the question. It's an important question because, once again, I think the committee is so focused on writing legislation that's somehow going to magically make this problem disappear and prosecute people. Even new legislation is going to require evidence. Evidence comes from witnesses. Witnesses who are safe and secure and receive proper supports in telling their story tell the most effective story, compelling stories. Those stories are what inform judges, what cause them to adjudicate matters, what cause them to find guilt in appropriate cases where elder abuse has happened. So what you need to do is fund the same thing in the domestic sphere. You need to provide support people to help these victims tell their stories. You need to provide resourcing to police divisions, to police associations, to police forces, to allow them to videotape that testimony. So when issues of competence arise later, that videotape testimony can be introduced under Section 715.2 of the Criminal Code. And I see I'm just about out of time.
Those are some good suggestions. Thank you. And thank you, Madam Chair.
Thank you, Madame Findlay. Donc, c'est au tour de Monsieur.
It's Mr. Varani's turn. 5 minutes. Thank you, Madam Chair. I'll begin by thanking all witnesses for their testimony here today.
Robust discussion. I'm going to give a special shout out to Ms. Tamlin Watts, who happens to be my constituent as well. Thank you for all of your work in this area. You know, you're lecturing in this area and your work with CanAge, and for your advocacy, but specifically also during this pandemic when advocating for seniors has become the norm for all of us because of what we've seen over these last 15 months. So let me start with you, Ms. Tamlin Watts. We've had this rife discussion over the last 45 minutes between amend, don't amend. And I heard what you said most recently to Mr. Garrison, but can you give us your perspective on why you feel the current laws are insufficient and that a new charge should be enacted in about 90 seconds, possibly? Thanks.
There are gaps in the law that do not necessarily meet the underlying basis that we have right now. Police, and I teach police across this country, consistently say that they do not have the tools that they need to move from what they know is problematic and criminal behavior and work with that in the code. And we also know, of course, that much of these behaviors are pattern behavior like other forms of abusive behavior, and we need to call those out as well. We need to name abuse before we can even think about responding to it or moving to sentencing. If we cannot name them, if we cannot charge them, we stop there, and that's a problem.
Okay, thank you for that. So it's a bit about that symbolic denunciation piece that you mentioned earlier as well. And can I pivot to something as well? And I'm going to ask you first and then Mr. Burks. Tell me about the notion of prohibition orders. And what I mean by that is just this concept. I mean, you teach all this kind of stuff, but for the purposes of everyone's understanding, if we were to have not only, so whether it's the current provisions in the code or potential new provision, someone is found guilty of some form of elder abuse, and on sentencing, a prohibition order could issue saying that, and also thou shalt not work in a sector that deals with seniors for a period of 5 years, 10 years, etc. Is this a good idea? And two, do we have that tool currently, or would that need to be amended into the code to make that possible?
Thank you. In my respectful view, there is probably a way you could squint at it right now and try to get people not to work in certain areas. Here, of course, we're looking about paid caregivers, perhaps either in the private pay section or whether or not we're looking at an institution. There is nothing right now civilly, and I point this out because there is a gap that perhaps the criminal code could assist with. There is nothing civilly that would stop a person who's a paid caregiver in any part of this country who may have been charged or found guilty of any form of, let's call it, elder abuse by getting another job. There's no registries available, and I am part of the National Long-Term Care Technical Standards Committee, and that is a piece that we're looking at, but there is nothing there now. It would be, I think, very important to be thinking about how to make sure that we have prohibition orders for people who have been convicted. And again, it's important to know that we have many, many, many repeat offenders. So we're not just necessarily looking at one person in one relationship, but where we have paid type of caregivers, this tends to be ongoing abusive behavior. I think a prohibition order with those types of denunciations in them, with those pieces that would stop or inhibit, would be a very useful tool.
Okay, thank you. Mr. Burks, give you a chance to address that in about 60 seconds, please.
I will try and confine it to 60 seconds. So in terms of what is there right now, if someone is found guilty or convicted, they can be placed on a probation for a period of up to 3 years with conditions. And one of the conditions would be a prohibition on them working with the elderly. Second of all, when someone is convicted of a criminal code offense, they get a criminal record, and they would have to apply after 5 years to have that record suspension removed. And so in order to license someone or to employ someone, all an employer has to do is run a criminal background check. Because you're dealing with vulnerable individuals, it would be a vulnerable sector check. Now, I know in Ontario, we've just enacted legislation, and if a person had been convicted of an offense involving an elderly person, such as an assault or criminal harassment, that would pop up on that vulnerable sector search. So the employer should be able to find out that they have a criminal record. So those are two tools. And in terms of denunciation, once again, and I apologize if I sound like a broken record, denunciation doesn't necessarily come from having something be a criminal offense. Denunciation comes from educating the public. We are not going to stamp out impaired driving simply by legislating it. We've legislated against impaired driving for 50 years and it still happens. It is sustained public education on the carnage on our roads that will finally stamp that out. And it is that same education that will finally bring elder abuse out into the light and hopefully minimize it.
Okay. Thank you very much.
Thank you very much. We'll now go to Monsieur Fortin for 2.5 minutes. Please go ahead.
Merci, Madame la Présidente.
Thank you, Madam Chair. Thank you again to all our witnesses. Unfortunately, those I don't ask questions of aren't, well, it's not because I don't find you interesting, but I have very little time. Mr. Prudhomme, I understand that you sit on a committee on aging at the UN. It would be interesting to know what the UN is projecting on this issue, the issue of elder abuse. Thank you for the question. Yes, for 3 years, from 2013 to 16, a number of experts from all countries around the world reviewed the various tools that either existed or could be put in place to protect the rights of seniors. I'm going to focus on what you asked. It was seen that there were no specific tools focusing on the rights of seniors, as the UN did for women and children and Indigenous people. It would be good to have an international convention that would protect the rights of seniors, and tools would flow from that, either be created or be amended, and that would make it possible to move forward and provide good protection against elder abuse. The committee looked at everything that includes abuse and fraud, focusing on seniors, people with mental problems, and handicapped seniors are included, of course, but the majority of seniors are not mentally or developmentally disabled in any way. If you could resume with a summary of the broad outline of what you've been discussing. It's the right to social participation, so continuing to participate and contribute as long as they can. So it's not because you have a certain disease like dementia. There are still moments of lucidity. And in those lucid moments, people can take control of their lives. In Quebec, adaptations are already being made to make sure that the lucid periods of people with dementia are taken into account. When can we expect some progress? Is there a timetable? Your time is up, Mr. Fortin. Just the date. It'll take about 10 years, unfortunately. Thank you, Mr. Prudhomme.
Thank you very much. We'll now go to Mr. Garrison for 2.5 minutes. Please go ahead.
Thank you very much, Madam Chair. I wanted to return to the witnesses from CanAge to talk again a bit more about the question of corporations being held responsible for their failure to provide care during the pandemic, and whether CanAge would believe that the Criminal Code can actually get at corporate ownership when it comes to the policies that keep precarious workers working in long-term care homes, and other kinds of things that contribute to the terrible tragedy we saw in long-term care homes.
It has been a terrible tragedy. With respect to Mr. Burks, there are certainly, of course, some provisions never used in Canada against long-term care homes. I respectfully believe, however, that the current criminal code provisions does not go far enough to be able to reach into those areas and speak about the criminal endangerment. It is a challenge when it comes to things like private and public and municipal homes. I don't believe it could be any way in particular that you could delineate them across this country. We have different ways of funding long-term care, but there is about a 50-50 mix of public and private. I do believe in the development of national standards, but I would also offer that that needs to be tethered with dollars, and there needs to be tethered with a Bill of Rights associated for elder abuse and older people. So I do not think that the criminal code goes far enough in creating a charge that actually will ever get laid against long-term care homes as is. And I think that there's study that needs to be made available about criminal endangerment to respond to those issues.
Thank you very much. I want to return to Canadian Bar Association, and first of all, make it clear that I thank you for putting the emphasis on the other things we need in order to bring attention to the problem of elder abuse, other than just an amendment to the criminal code. And I appreciate the fact that you said you favor national standards. Do you believe that if there were national standards, the failure to meet those standards on a systematic basis would be covered by the current criminal code provisions?
So, in terms,
I'm going to take this one for a second, Jody. You can chime in a second. The reality is, as our position is made very clear in terms of our written brief, there are criminal code provisions. What we are looking for is creating standards and knowledge. So I would, Jody, I'm sure will chime in if he thinks differently, but I do believe that if we were clear about what the expectations were and what the knowledge that our team on the ground, be they judges, lawyers, not lawyers, but prosecutors and police, if they know what the test is, so to speak, that then they can absolutely apply the criminal code as it is. Jody?
I agree. I concur. In terms of there's a difference between evidence and between charges, and having national standards would provide that metric, that evidence needed in a prosecution in order to secure a conviction. A breach of that standard is prima facie evidence.
Thank you.
Thank you. Thanks very much, Mr. Garrison. Thank you to the witnesses. At this time, we will suspend as we bring in our next panel of witnesses, but I must say that that this whole conversation today has been very compelling, very, very strong testimonies by each and every one of you. I really appreciate that in terms of how much it will inform our study. Thank you again, and we'll suspend for a couple of minutes as we bring in our next panelists. Thank you, everyone. Our witnesses joining us on this panel. Just a quick housekeeping
Appel au
note.
règlement, Madame la Présidente.
Oui, monsieur.
I am told that there is no interpretation in French at the moment.
On me fait signe que c'est revenu, alors
There it is.
je retire mon appel au règlement. Désolé, Madame la Présidente.
I withdraw.
Just clarify that with Mr. Clerk if we're having ongoing issues with translation.
Oui, l'interprétation.
The interpretation is working well at the moment. Thank you.
Thank you very much, Mr. Clerk. Okay, with that, I'll introduce our witnesses. And just before I do that, I'll just go over some housekeeping rules. Please take note of the interpretation bar at the bottom of your Zoom screen. Please select the language that you'd like to listen to. You can speak in any language that you choose, any English or French. When you are not speaking, ensure that you're on mute. And when you are speaking, please wait to be recognized by the chair. And ensure that you're speaking slowly and clearly so that we don't have any translation or interpretation issues throughout this process. I do have this 1 minute and this 30-second card to help you keep time. And with that, I'll introduce our witnesses for the second panel. We have the Council to Reduce Elder Abuse, represented by Sherry Baker, Executive Director, BC Association of Community Response Networks. We also have Seniors First BC, represented by Marie-Noëlle Campbell, Executive Director and Lawyer, and Eric B. Clavier, Lawyer and President, Board of Directors. And lastly, Statistics Canada, represented by Jeff Latimer, who's the Director General, Health, Justice, Diversity and Populations, and also Kathy Aucoin, who is the Chief of Analysis Program, Canadian Centre for Justice and Community Safety Statistics. Welcome to each and every one of you. We'll start for 5 minutes with the Council to Reduce Elder Abuse. Please go ahead and unmute yourself. You have 5 minutes.
Thank you, Madam Chair and honorable members of the Standing Committee. Thank you for the opportunity to contribute to the important work you are doing to study elder abuse in Canada. I am proud to be able to describe to you the fine work being done in British Columbia to raise the awareness of abuse, neglect, and self-neglect, and to help our communities find ways to prevent it. The last 2 provincial governments have recognized that this issue is often hidden, little understood, and extremely damaging to older and vulnerable adults throughout the province. For the last 10 years, they have funded the work that our organizations are doing, and it is my distinct pleasure to have been involved since the beginning. I have written a more detailed description of how the BC Association of Community Response Networks and the Council to Reduce Elder Abuse are organized to work towards reducing elder abuse by concentrating on supporting a local community response. Here is just a sampling of the issues and remedies which you can consider. For example, middle-aged children of aging parents find it difficult to help their growing family's needs. They see their parents with assets and they think it would be a good if they could just have their inheritance before their parents die. 2, when companies find themselves having to downsize, or as is happening during the COVID pandemic, having to lay off workers, many wage earners are finding themselves desperate and move back into their parents' home, often with children. 3, immigrant families often bring older family members from their homeland to help look after the children. Sometimes these older adults are not provided with any freedom to create a safe life for themselves, which is further hindered by the inability to speak English or French. 4, adding to the challenges of reconciliation, decolonization, and the impact of residential schools, some of the older Indigenous Canadians are also faced with the pressures from their younger family members who expect them to provide financial support to help them deal with their own issues. So I would like to list some of the ways that the federal government can play a role in reducing elder abuse. It can understand that it is a systemic issue and there is no quick fix. When considering mandatory reporting, understand that most elder abuse is perpetrated by family members, and few parents will report or lay charges against their own child. This could have the effect of driving the abuse further underground. As Krista James of the Canadian Centre for Elder Law said at the last hearing, abused adults don't want their family members to go to jail. They just want the abuse to stop. It can provide support for law reform initiatives. It can provide support for the key role played by the RCMP so they can respond effectively. It can provide support for research projects which help seniors live safely in their own home. It can provide support for research into what causes elder abuse. It can provide support for safe and accessible housing projects for elders. It can provide support for job creation and retraining for people trying to enter the workforce or are dealing with, with being downsized or laid off. It can provide support for training for frontline workers in institutions as well as in the community. It can provide support for English as a second language projects for immigrant seniors along with other settlement services. It can provide support for Indigenous communities in developing safe and healthy housing for their families and elders. It can provide support for mental health and addiction services, especially for families in crisis. No individual can be forced into therapy, so there needs to be supports in place to help them want to change. It can provide support for the development of safe and accessible transition houses for older adults and allow a longer stay in BC. A woman can only stay for 30 days in a transition house. And it can provide support for the development of a national elder abuse strategy. I've included a lot more information in the brief that I've submitted to you. I look forward to answering your questions. Thank you.
Thank you very much, Ms. Baker. We'll now go to Seniors First BC for 5 minutes. Please go ahead and unmute yourself.
Okay, hope you can hear me. Madam Chair and honorable members, thank you for inviting Seniors First BC to speak today on the important issue of elder abuse. Seniors First BC is a nonprofit organization that provides direct services to vulnerable seniors across the province of BC. Our services include a senior abuse and information line, victim services, legal services, and the public education and outreach program. The Senior Abuse and Information Line is our organization's front door, and we have attached statistics on calls to our brief. Between 2019 and 2021, the two most common types of abuse reported by callers were 1, emotional and psychological abuse, and 2, financial abuse. This will be the focus of our presentation today. Regarding psychological and emotional abuse, as we've heard, most abusers who are family members, most abusers are family members, and most seniors do not wish to involve the police due to a combination of fears of repercussions for their loved ones, concerns about finding an alternative caregiver, but also due to the belief that they will not be taken seriously. Our workers frequently report hearing complaints about agencies disregarding the older adults' concerns, assuming that they have dementia, are incompetent, or do not understand what is happening to them. Our victim service workers also hear from clients who actually have contacted the police, and the abuser has actually encouraged them to call the police because the abuser already knows the routine. A police officer comes, de-escalates the situation, and leaves. Shortly thereafter, the abuser returns. Sometimes the police refuse to write a report because they consider this to be a civil or family matter. We have heard positive stories about local enforcement, typically in which the officer listened to the older adult story, had a frank conversation with the abuser, sometimes warning them of possible criminal consequences, and followed up with the adult. This successful approach typically comes from smaller communities in BC. Our recommendation is therefore to provide better training on dealing with elder abuse to local enforcement agencies, including, and to encourage investigation and follow-up. In the context of abuse in institutionalized care, we support Graham Weber's recommendations to create the distinct offense of criminal endangerment and to provide strong whistleblower protection to residents and substitute decision makers. Regarding the second common type of abuse reported by color, it's financial abuse. And most financial exploitation of seniors, again, involves a family member or person in a position of trust through either a power of attorney or joint bank account. Fraud also happens more and more frequently through international scams. Unlike credit card companies, banks and credit unions do not monitor for suspicious activity on their clients' account. In the rare instances where financial institutions have been sued for negligence, courts have found that they did not hold any duty of care to their account holders or third parties. Ideally, there should be a legislated duty of care for financial institutions. Potential confidentiality issues about customers' accounts could be covered in the account agreement. Another possible first step would be to introduce legislation protecting whistleblowers at financial institutions, like the US Senior SAFE Act, which provides immunity from liability in any civil or administrative proceedings to trained employees of financial institutions, such as bank tellers, advisors, investment bankers, who report potential exploitations of senior citizens, even if it would otherwise violate privacy legislation, and they provide the training. In our opinion, raising the alarm, if followed by investigation and action from law enforcement, would at least have a freezing effect on the author of the fraudulent behavior. Thank you.
Thank you very much, Ms. Campbell. And just for your note, for your next interventions as we go on with this meeting, can you please put the inline mic closer to your mouth? That would be much appreciated in terms of sound and interpretation. Thank you.
Madam Chair, thank you.
We'll now go to Statistics Canada for 5 minutes for your opening remarks. Please go ahead.
Madam Chair and members of the Standing Committee on Justice and Human Rights, I'd like to thank you for the opportunity to present our most recent statistics on senior abuse in Canada. Much of the information that I'll be focusing on this afternoon is available in the publication Family Violence in Canada, a Statistical Profile. A link to the report and a series of custom tabulations have been provided to the clerk for your reference. It's important to note that the data from this report highlight those forms of abuse that meet the criminal threshold and which were reported to the police. As a result, it does not provide a complete picture of the overall prevalence of senior abuse, as it does not capture emotional, psychological, and financial abuse. Also note that Statistics Canada is working towards collecting disaggregated data, that is, by ethnicity, life stages, and gender, which will give us a better understanding of which seniors are most at risk of abuse. Also note that I'll be referring to the most recent police data, which is from 2019. The 2020 data will be released at the end of July, and this information will be critical to our understanding of the impact of COVID restrictions on seniors and whether or not they were more at risk of being a victim. In 2019, there were more than 14,000 senior victims of police-reported violence in Canada. By senior victims, I mean those individuals 65 years of age and older. Of these victims, 55% were men, while 45% were women. This translates into a rate of 227 seniors per 100,000. Since 2014, there has been a steady increase in police-reported violence perpetrated against seniors. Specifically, we've noted a 29% increase in victimization rates between 2014 and 2019. Over the same time period, the rate of violence increased more for senior women than senior men. And we noted also that there was increases in violence against other age groups, that is people between 0 and 17 or 18 to 64, but it was only an increase of 16%. Based on the police data, the highest rates of senior victimizations were noted in the 3 territories, as well as Manitoba and New Brunswick, while Nova Scotia reported the lowest. According to the 2016 census, 7% of all seniors lived in shared dwellings, such as a senior resident nursing home. From police-reported data, we were able to get a glimpse of the violence committed against seniors in these environments. In 2019, just over 1 in 10 senior victims of police-reported violence were residing in a nursing or retirement home at the time of the incident. 2/3 of these victims were senior women. Most of these seniors who experienced these violence experienced physical assault, while 1 in 7 were sexually assaulted. Within the nursing and retirement home environment, the perpetrators of this violence were most often a senior themselves. They were a casual acquaintance of the victim, a neighbor within the retirement home, or but what we can't tell from the data whether these individuals were suffering from some sort of cognitive impairment or dementia, which could have explained the reason for the violence. Further to that, the police reported data noted very few cases where the perpetrator of the violence was a staff member of the residence. Another source of data of senior abuse is the General Social Survey on Victimization, which measures 3 types of violence: sexual assault, robbery, and physical assault, as well as 5 forms of nonviolent crime. These data are critical to our understanding as they capture victimization, whether it was reported to the police or not. According to the 2019 GSS, 1 in 10 seniors self-reported being a victim of household or violent crime in the previous 12 months. 84,000 seniors were a victim of a violent crime. Through the GSS, we are also able to capture experiences of emotional and financial abuse of older adults by a family member or caregiver. Recent results found that approximately 2% of seniors reported experiencing financial or emotional abuse over the past 5 years. Finally, the GSS also noted that 14% of seniors experienced fraud over the previous 5 years. There are challenges in collecting data on elder and senior abuse. Specifically, to obtain robust data, there must be an agreed upon definition of senior, an agreed upon definition of abuse, and a sound method on how to capture this information from those living in an institution. Thank you to the chair and members for your attention this afternoon. Thanks.
Thank you very much. I appreciate that. We'll now go into our rounds of questions, starting with Madame Finley for 6 minutes. Please go ahead.
Thank you. I'd like to thank all the witnesses for being here with us virtually today, and an especially warm welcome to those from Seniors First BC and the Council to Reduce Elder Abuse. These BC organizations do important work in my home province. Ms. Baker, I found your itemized list of issues and federal supports would be beneficial to be particularly useful. Thank you. I will be directing my first questions to Mr. Latimer and Ms. Aucoin. Well, maybe just Ms. Aucoin if Mr. Latimer is sidelined a bit. From Statistics Canada through you, Madam Chair. We know the importance of data in addressing issues relating to elder abuse, data that, as this committee has heard throughout our study, is largely missing. The testimony of the Canadian Network for the Prevention of Elder Abuse emphasized that group's disappointment that the 2021 budget did not commit to better collection of elder abuse data to inform our policy making, especially since the mandate letters of both the Minister of Justice and Minister of Seniors call for exactly that. So could you elaborate on where, in your professional opinion, the gaps exist in data collection with respect to elder abuse?
Thank you, Chair. That's a wonderful question. In 2008, Statistics Canada did a very comprehensive feasibility study to look at senior abuse and elder abuse to figure out how to fill a critical data gap. In having many discussions across the country with different experts, a key issue was the definition of senior abuse. Is it over 55, over 65? That was a key barrier that needed to be ironed out. Second to that was what would be included in a concept of elder abuse. The data that I discussed most recently was looking at police reported data that relied on criminal code definitions. So elder abuse as an entity has not been embedded in the criminal code. So understanding relationships and trust, emotional abuse, physical abuse, psychological abuse, how is that measured? Third, how do you measure it for amongst a population that's in an institution that is hard to reach, who also might be suffering from a cognitive disability that cannot report on what they're experiencing? Do you do a proxy interview? Do you interview their family members? there are many barriers and challenges. That's not to say one shouldn't measure it, but to create an overall prevalence of seniors in an institution and their levels of abuse is challenging.
I appreciate you underscoring some of the ways to overcome these data collection challenges, and I wish you well in that work because it's very important to do so. You mentioned also working toward collecting disaggregated elder abuse data by ethnicity, gender, and so forth. Could you elaborate a bit on your progress and when that data might be available?
So through the budget, there was funds provided Statistics Canada to explore and work on creating more systems to release disaggregated data. So our police data will start collecting ethnicity data in sometime in the near future. We are going through the feasibility of how to capture that information.
Thank you. This to Seniors First BC, either whoever wishes to respond, but we just heard from Ms. Aucoin and other witnesses before the committee a real need to clearly define elder abuse. Generally, it seems for data collection, but also in the criminal code. Do you have an opinion as to any potential amendments to the criminal code might help, including a definition of elder abuse, or what that definition might look like?
I'll defer to Eric Clavier on this question. We do not, just so you know, we do not engage in criminal law work for the definition of elder abuse. We have followed the definition that was provided before by there was an ebook published by the BC Ministry of Public Safety and Solicitor General in 2013, and we have followed that definition.
So any thoughts on a further, better definition, or have not put your minds to
that? We have not really put on mind. Okay, I haven't, right. But maybe Eric Clavier may have more to say to this.
Yes, thank you. I've also not put my mind to a definition of elder abuse. I think one of the difficulties that we all recognize is that elder abuse is a pretty generic concept, and it's certainly something which we need to look at as to what would comprise a more lineated definition. As Marie-Noelle or Ms. Campbell has noted in her opening remarks, is that the most prevalent abuse that we see includes financial abuse here. And that could be something which is not necessarily related to elders, but which would be specifically targeting, or if you could have a definition that specifically targets that kind of elder abuse where people take advantage of joint tenancy or joint accounts, that may be helpful. But unfortunately, I am not able to come up with a definition that I think would be useful to the committee today.
Well, that's fine. I think this is my last question. So I know that you service more than 200 clients a month. Could you speak to how legal needs of your clients may have evolved since the beginning of the pandemic?
Very briefly, please.
Like, where is your help being sought?
Ms. Campbell would be the person to answer that, in the sense that she's in charge of the organization's elder law clinic as well.
Sure. Request for legal assistance has boomed. The funding hasn't really followed. It has been limited because it comes from the Law Foundation, and they do what they can. We hear a lot about abuse of power of attorneys, abuse related to joint tenancies. We do what we can, but maybe I will provide more information in writing.
That's
Thank
great.
you very much for that.
That would be good. Thank you, Madam Chair.
Thank you. We'll now move to Mr. Sarai for 6 minutes. Please go ahead.
Thank you, Madam Chair. I want to thank the two organizations from British Columbia, the Seniors First BC, as well as the Council to Reduce Elder Abuse. Thank you for your services and constant commitment to senior issues and preventing senior abuse. My first question is maybe to you, Ms. Campbell. In your opinion, what steps can be taken to report to improve reporting of abuse among seniors?
Thank you, Madam Chair. I don't think the issue is necessarily with reporting, but with follows through. What we're hearing from our workers is that when there is a report to police, no steps are taken. People do not hear back. Even as we mentioned, there is little follow-up done except in smaller communities. So what would be helpful to see that follow-up either by house checkups or by investigations. Our victim service worker has informed us that she has never seen any case reach the level of prosecution in spite of police reports and being made.
And what about, do you see that there's different issues with those that have disabilities or language barriers? Do you think there should be any specific recommendations to flush those cases out as well?
Yes, thank you for this question, Madam Chair. So one of the issues we see is the presence of relatives as interpreters, whether it's at bank when older adults want to open a joint account and they serve as interpreters at the bank, which is problematic. Obviously, they should not be in that room. We see that also with seniors who want to change their address or information about their accounts. When they call Service Canada, there is no interpreter. So oftentimes the relative who may be an abuser serves as interpreter. So an easy first step would be to have more interpreters for Service Canada and at banks to ensure that whenever someone is given authority, whether it's through a power of attorney or because they become a joint account holder, that the relative that will be the beneficiary of this instrument will not be in the room and that the older adult is informed of the risks associated with granting that authority.
And in a case of disability or such as say a hearing or speaking disability or language disability, are you also suggesting the bank or just like Service Canada also provide an interpreter or assistance in their language or means of communication?
Yes, that would be helpful.
Okay, thank you.
Thank you.
Ms. Baker, I'll ask you this. You've said that reporting it's there, but actions don't happen afterwards. Can you give us some insight or recommendations on how we can get more follow-up on cases such as what Ms. Campbell has just stated or what you have seen, so there is some follow-up and there is some protection for those that are elderly and being abused?
Thank you for your question. My organization provides support for the communities to develop a community response. We're not doing direct service provision to the individuals who are being abused, but rather we're helping our communities, members of the community, neighbors, friends, and families in the community to recognize the signs of abuse and then to know where they can be referred for service. And Seniors First is and the line, the services that they provide are one of the referral agencies that we use throughout our province. So what we do is we have 81 community response networks in British Columbia serving 233 communities. And our role is to develop the awareness of abuse and neglect and self-neglect. And we provide it in, we have a Chinese network. We're developing a Punjabi speaking one. We have Indigenous networks. We have LGBTQ networks, people and are open to wherever they want. And it is driven by the communities themselves, not from our provincial organizations. So that's why we have the two organizations. The BC Association of Community Response Networks is a local, and then the Council to Reduce Elder Abuse is like a provincial network where we bring together all the other organizations that are providing services so that we all know what each other is doing. So I don't think I've answered your question because I'm not really qualified to answer the question directly that you asked.
Maybe I'll go to Ms. Campbell real quickly. If you can help me on how do we get more reporting, especially if it is a family situation where there's a strong hesitancy to report your own son or daughter as somebody trying to report, as somebody trying to manipulate or abuse your, specifically for financial reasons or even in cases of abuse. Any quick comments on that?
What would be helpful, and I would echo, I think it was Benedict Schopflin, the executive director of the Canadian Network for the Prevention of Elder Abuse, who suggested that to have mediators. And because reporting is difficult, people are afraid of going to the police. And when they go to the police, as mentioned, it does not really go anywhere as far as we hear. It might be helpful to have mediators who specialize in elder abuse, who then talk to the alleged abuser and the older adult and try to find a solution together.
Thank you.
Thank you.
Thanks very much. I will now go to Monsieur Fortin for 6 minutes. Please go ahead, sir.
Merci, Madame la Présidente.
Thank you, Madam Chair. Thank you to all our witnesses here today to shed some light on these very important issues. My question is to Ms. Campbell. Ms. Campbell, in your introduction, you talked about the U.S. PayerSafe Act. You're a member of the BC Bar, but of the New York Bar as well. Please do talk about the U.S. legislation. In what American states, U.S. states, does it apply? And what are the provisions that this statute contains?
Your mouth so we can hear properly, please.
D'accord.
I'll answer in French since the question was put in French. What I understand is that the Senior Safe Act is from a Maine initiative, the Maine Safe Senior Training Program, a training program in Maine because Maine has the highest number of seniors in the U.S. The Senior Safe Act, if I understand correctly, is a national statute. In Maine, it was established in collaboration with the North American Security and Administrative Association. It provides training to banks to explain how to recognize exploitation and abuse of seniors, be it by members of their family or because of international fraud, false advertising, and so on. They can report to individuals identified in the legislation, so not just to anyone. In Canada, for example, reports could be submitted to designated agencies, which would then have responsibility of following up. So they provide for a mechanism that makes it possible for bank employees to sound the alarm and try to put an end to the issue. Sometimes seniors are not aware of what's going on with their deposits and of what transactions are being carried out on their accounts, and the legislation can stop that type of behavior if a report can be made and investigation carried out. But this should not cause a problem with disclosing information, because normally a bank employee has no authority to disclose transactions on a bank account. Yes, thank you. You're saying that this is a training issue, but there is a U.S. Senior Safe Act, so therefore this is a statute, and I don't know the statute, but it must provide for more than training. There must be authority for bank employees to report abusive conduct. And I think we could use something like that here, because there's certainly economic abuse, and people in financial institutions should have the tools to keep an eye on it. Does the Safe Seniors Act also provide for protection against abuse, physical ill treatment? No, it is limited to financial exploitation of seniors. So if I understand correctly, it protects whistleblowers in financial institutions. You say that it also provides for training provided to bank employees, correct? Yes. They are protected only if they have received the training. So stage one is training the bank employees. After that, they're given a list of people to whom they can report abuse. Are you aware of the results of this legislation? Has it led to good results? I was looking for statistics. It's a statute dating back to 2018. So I have stats only on the main model, which seems to be working well, but the numbers aren't very clear. I found no clear figures. There's certainly an increasing number of reports, but we have no clear stats to show how well it's working. If I understand correctly, you also don't know whether other states have adopted similar legislation? This is a federal statute. The state of Maine has its own training program, but the federal government followed suit by adopting a federal statute. I have less than 1 minute. Thank you, Ms. Campbell. We talk a lot about economic abuse, but there's also physical abuse and negligence of seniors, and we've saw that very much during the COVID period. Should we not amend the criminal code and create new criminal code offenses? Or are the existing offenses sufficient, and should we be working on applying them properly and providing appropriate training? Quickly, in my opinion, we agree with the recommendations of Graham Webb to create a new provision, and we believe there should be follow-up to requests by seniors and complaints made by seniors. We see that there are police reports. Even when a complaint is made to the police, there's no follow-up. So yes, there should be follow-up. You mentioned Graham Webb. Could you spell that for me, please? Just to get the name right. How do you spell Graham Webb? W-E-B-B. G-R-A-H-A-M. Last name W-E-B-B. Thank you.
Thank you very much, Monsieur Fortin. We'll now go to Mr. Garrison for 6 minutes. Please go ahead.
Thank you very much, Madam Chair. And I want to particularly thank the witnesses today, starting with Ms. Baker, for emphasizing the diversity of seniors. I think that we sometimes fall into the trap, as we do as a society, of considering seniors as a homogeneous whole. And so I'll start with the question to Ms. Baker. And do you think that federal government programs sufficiently recognize that diversity among seniors, whether it's ethnicity, indigenous status, or sexual orientation and gender identity? And is there more the federal government could do to recognize that diversity?
I'm not sure of the extent that the federal government is recognizing it, but I think it is becoming more and more of an issue, especially with the indigenous populations and the immigrant populations. I think it is becoming a really important distinction that we've embraced it in BC in the work that we do, and we are open to providing the opportunity for any group that wishes to be looking at this issue from their own lens. Then we will support that, of course. I'd like to also emphasize the importance of looking at what is causing the abuse, like the abusers. Why are they abusing their older adults in their families usually, or their community? And what is it about the community itself, which is some of the reasons why I offered some possible areas of concern that the federal government could look at. And it is cross-cultural. It doesn't seem to matter whether it's a European or South Asian or Oriental, or whoever it might be. There is every community has issues around elder abuse within their societies, but it's increased when the the society is suffering as it is with the COVID or with downsizing and all the other things that are happening within our economies, we find that people who are in those positions are more likely to thrash out at people who they perceive to be have more assets, more ability to look after them.
Point of order, Madam Chair. The interpretation is not working.
Thank you for pointing that out, Monsieur Fortin. Can I just ask Mr. Clerk if something's going on?
Well, if you would like to resume the deliberations or say a few things, I would like to check indeed if interpretation is functioning.
Just to prevent what lack of communication, maybe we'll just pause as you check on that. Thank you. I've paused your time, Mr. Garrison, just so you know.
The interpretation has resumed.
Perfect. Monsieur Fortin, is your interpretation is now working?
Présentement, oui.
Yes.
Thank you very much. Mr. Garrison, you can please go ahead.
Okay, thank you very much, Madam Chair. We recognize that the majority of seniors do not live in long-term care homes, but the COVID crisis and the degree of isolation that some seniors face in long-term care homes certainly is problematic. And so I wonder, maybe I'll direct this to Ms. Campbell, in terms of the services you provide, do you often hear from seniors in long-term care homes? And do you believe that in long-term care homes, there are sufficient staff available, like social workers, who seniors could reach out to locally if they are experiencing abuse?
Thank you, Madam Chair. For this question, I'd say that only 6% of calls come from people in long-term care or institutionalized care in general. So we're not clear if that's because there are fewer issues that come with those who are in long-term care residence, or it's because we don't have the means to reach them sufficiently. So in terms of your question about do they have enough time? No, I've heard during those sessions that normally it's about 4 hours that they should receive. What I'm hearing is that in assisted care, they receive less than 1 hour per week, and generally in long-term care homes, it is significantly less than that, 2 to 3 hours at best. So I agree that there should be more staff. I believe that money has been earmarked to assist with training new staff and to help with that. The issues we have and that we hear is that when seniors report abuse is that family members are afraid to report it. They are afraid of repercussions. So again, it would be helpful to have either mediators or more a whistleblower protection in those instances, as suggested by Graham Webb. Thank you.
Okay, I'll end my questions there, Madam Chair.
Thank you very much, Mr. Garrison. And you left a minute on the clock, and if you don't mind, I'd like to oblige by a very quick question to Stats Canada. In the previous panel, we heard from the Canadian Bar Association about the importance of enforcement, not just of creating crimes in the criminal code with respect to elder abuse. I'm just wondering if there is a very targeted approach to collecting data with respect to not just the crimes on which people are convicted, but also maybe that full range of crimes, or any way in which we could identify exactly how or where that enforcement is lacking.
That's a great question, Madam Chair. I would suggest a question for the Canadian Association of Chiefs of Police could really focus on enforcement. What we do when we collect police reported data is it's all lined up with the criminal code. We have full coverage with all police services across Canada, and there's a coding manual that outlines what is being captured. I did listen into the previous witnesses, and the link was made to family violence, 20, 25 years ago, with training of police officers and understanding family violence, the dynamics. With training over time, processes change, but how enforcement follows through, it would really be a Canadian Association Chief of Police question.
Thank you very much for that. I very appreciate it. And with that, I'd like to thank all of our witnesses for your excellent testimony today, and thank you, members. And I will see you on Thursday for committee deliberations on drafting instructions for our elder abuse study. In the meantime, meeting is adjourned.
Merci.